Introduce our last speaker of the morning, Buck Files, who's coming to the podium now, is been a criminal defense lawyer for 40 years, and he was recently elected the first criminal defense lawyer as the president-elect of the State Bar of Texas in 34 years, so that's quite an achievement. He began with a BA from Austin College, where he's on the Board of Trustees, and his law degree from SMU. And without further ado, Buck Files.
May it please those courts who are assembled here today. This is as interesting a group as I will speak to. Defense lawyers, judges, legislators, county commissioners, court administrators, and a few interested citizens who are all here today to discuss what is of tremendous importance to me, and that is the indigent defense problems which we have in Texas. I want to thank you for making the sea in which I swim as a small fish a better place to be. I was asked to do two things in my presentation: to talk about the right to counsel, the fact that it's comparatively new as a concept and it's a fragile right, and then to reflect on what it is to be a defense lawyer working in both the hired and appointed systems. I'm one of those lawyers who had graduated from law school by the time Gideon came out. So Gideon turned everything that I had learned in law school on its ear as far as right to counsel. I went back and looked at a couple of cases from before 1960, at a time when there were no rights to counsel except capital cases or on an individual basis if something was terribly complex. There's a case misnamed Hope. It was out of Court of Criminal Appeals in 1950. It was a robbery case. It was originally a capital murder case, but the state had abandoned that portion of the indictment which made it capital. And the defendant, who was 27 years of age, was convicted. He was given a 50-year sentence. He appealed, but he was told that if he didn't drop his appeal, that his good time would be taken away. Then he comes back on a writ of habeas corpus. And in his writ, he says, I was 27 years old at the time of my conviction. I had only been through the 8th grade in school. I was ignorant and unlettered in the law. I had been convicted once before, and I had received a suspended sentence. When I asked for an appointment of counsel in this case, I was told that I could not have one. I attempted to defend myself, but the district attorney told me that I couldn't ask the questions that I wanted to. I was too poor to have a lawyer, and my relatives weren't there for me. I was convicted. I did appeal, but I was told that if I did, I was going to lose good time. Court of Criminal Appeals says under the old Article 494 that the trial court had no duty to furnish him an attorney because this was not the trial of a capital case. And then they turned what he had said against him. Here's a man who went to school till the 8th grade. He'd been tried and convicted previously, and he evidenced sufficient knowledge in such matters as to appeal his case and then to make the decision to dismiss the same. If our statute, Article 494, is allowed any dignity, he was not entitled under such to have an attorney appointed by the court to present his defense. The statute has not been repealed and still remains upon our statute books. Then Bush came along in 58. There the court granted habeas relief to an individual who was charged with under the habitual criminal statute, got a life sentence, and there was a problem at the time he went to court because there was an outstanding unvacated judgment finding him to have been of unsound mind. So when he came back for habeas relief, he got it. But there was a dissent which said, while the majority opinion in the instant case does not appear to expressly so hold, the inference to be drawn is that it holds that the failure of the trial court to appoint counsel in an ordinary felony case constitutes a denial of due process. As far as I have been able to ascertain, the Supreme Court of the United States has not changed its view on this subject. That wasn't long ago, my friends. As a young lawyer, I knew of that trial judge in Hope. He had left the bench and had become one of the most respected lawyers and citizens of his community. And like many of the other judges at that time, he was neither evil nor uncaring. He was following what he believed the law to be, but in hindsight, he and the other judges were terribly wrong. Even today, I would suggest to you, we cannot take for granted the indigent defendant's right to counsel. Now, Alex may not have as many problems in Houston as we have in East Texas, but I will tell you that unless we have enough enthusiastic lawyers to represent these clients, and unless they are properly funded in order that these lawyers may offer quality representation of the clients, we run the terrible risk of taking a step backwards to the detriment of these clients and to society as a whole. We run the risk of having a system that is form over substance. And I will tell you that the civil access to justice folks, whom I so totally support, are so far ahead of those of us in the criminal justice system. We do not have the most important and powerful people in the largest law firms in Texas supporting us. And until we enlarge our universe and get more support, we are going to move slowly, if at all, in a forward direction. To those of you who are lawyers, let me say that I am one of you in the court-appointed area. I can tell you the moment, almost, of the first court-appointed case that I had in my career. It was September 15th, 1970. The day before, I had been first assistant district attorney in Smith County, and I left the building that afternoon at about 6, and at midnight there was a catharsis, and I was a defense lawyer. And I went to work the next morning. And at about 11 o'clock, I got a call from Judge Galloway Calhoun, who asked me to come over. It was my birthday, and I thought maybe he had a present for me, and he did. There was a horrible capital murder, everything as bad as it can always be. The defendant who had the terrible record and no one who was going to be able to say anything for him. And of all the women to pick out to kill, he happened to pick out the mother of an elected district attorney in another county. I had the case for 4 years. Yes, he got a death sentence. Yes, Furman versus Georgia came along, and his sentence was commuted to life. And all those constitutional arguments that I had sort of faded away with Furman, and he died in the penitentiary. I still take court-appointed cases, and I will tell you, as president-elect of the State Bar and as president of the State Bar, I will continue to take appointed cases because I believe in the importance of doing so. We have a federal case right now that's at Fifth Circuit. There's a lawyer out of New York who figured out a cottage industry. He's representing the children, or they're now adults, who as children had pornographic pictures taken of them and out on the web. And he figured out that if he filed a case for $3.4 million in each one of these cases, he could make a lot of money. That case is at Fifth Circuit. Stanley Snyder and I are working on it together in the appellate system. We won in the trial court, won on mandamus, lost at the panel. We're going back to the en banc court, we hope. If we don't, we'll go to the Supreme Court because there's a conflict in the circuits. So what is it that those of us who undertake the defense of criminal cases are supposed to do for our clients? Are we to, in the words of our present disciplinary rules, are we to represent them zealously? What does that mean? I've known zealots who didn't have a brain. Are we to provide them with the effective assistance of counsel? I think as of last evening, there were 464 cases so far this year that the appellate courts had talked about ineffective assistance. So we can go back and read each one of those and find out what we're not supposed to do. No, we take a step backward in time to when there was a canon of ethics that said it all. When I broke into the practice of law, Canon 5 said it this way: a lawyer who undertakes the defense of a criminal case shall raise every defense under the law, in order that no man may be deprived of life or liberty without due process of law. And what is important, at the end of the sentence, there is no asterisk, and then at the bottom of the page, a corresponding asterisk, which says, except in court-appointed cases. We have precisely the same duty in a court-appointed case that we do in a hired case. We have the same duties to interview our clients, to send out a letter of engagement or contract or a memorandum to them as we would in any case, to take their phone calls. And this is an area I don't know the answer to. We take every phone call from the jail that comes in. We never turn down a collect call. I realize that for court-appointed counsel that this can be an impossible situation, but there has to be something around it. We make certain we furnish them with discovery timely so they know what the state's case is all about. we visit them in jail. And I'll tell you a secret. If you go to jail on Christmas Day and see your client and his family will love you forever. I was in Vietnam in '65. I know what it is to be away from home. And I have never missed a Christmas Day of visiting with my clients, and I never will. We investigate their cases, we negotiate their cases, and I don't know why, but some of the hardest feelings that I've ever had in a case, some of the most unpleasant negotiations, were over court-appointed cases that really weren't that big, but they were just as important as all the others, and then we tried the case. When I came to East Texas, there were great lawyers who were civil trial lawyers who did some of the best defense that was ever done. They did it for two reasons. They felt obligated and pride. And then there were some other folks who, when they introduced themselves, they would say, "I'm John Doe, and I'm court-appointed to represent Mr. Snerd here." And they were speaking in code. They were saying to the jury, "I don't want to be here, and I don't really like this man, but the judge has told me that I have to be there." And they did not do the job that they should have done. So what do they call us? Those of us who represent defendants in court-appointed cases or in hired cases, and I don't mean the unflattering terms, what do they call us? You look at me and you say, how simple can you be? We are lawyers or we are attorneys. And those of you who say that are exactly half right. But when you go back to your offices, those of you who are lawyers, and those of you who are not, you can crawl inside my brain and see how I think. You go back and look at that piece of paper on the wall and see what it says. And it says you are an attorney and counselor at law. And that opens up a whole new realm. And let me tell you what that means to me. It means that every client who comes into our office, or every person we see in the jail, whether we are hired or appointed, we know that they have two issues. The first issue is the obvious issue. It's the criminal justice crisis issue. They're accused of capital murder or theft or marijuana or whatever it happens to be, and that's where they are focused. But they have another issue. They have what I refer to as a rest of the life issue, whether they are a young puppy on the first offense or whether they have been there before and before and before. And if we are to serve as both attorney and counselor at law, we must be concerned about both of these issues. Have you ever thought about the fact that when you have an interview with your client, that they are looking at you as you would look at a medical doctor when you are going in and saying, "Yeah, doc, I know it's cancer, but what are we going to do about it?" And if we don't give them the same time which we would expect that doctor to give us, then we're not doing our job. Back in the early 50s, there was a Jewish theologian named Martin Buber who wrote a book entitled I and Thou. And I haven't looked at Buber's book for many years, but it made a real impression on me. It was about relationships. And Buber said you can break all relationships down into two groups. The I-thou relationship, in which each individual looks at the other person as a human being, an equal, a child of God. Or you can break it down into an I-it relationship, where the individual looks at the other person with whom he is talking as an it, an object. I'm convinced that how a lawyer conducts his first interview, or first meaningful interview, it may be, "George, I'm going to represent you. I'll come back and talk to you later." How he conducts that first interview says whether or not he's an I-thou person or an I-it person. We do basically the same interview in every single case. We start off with, "What do you want me to call you?" And when they tell me that, I say, "All right, you're George, I'm Buck, this is Carrie or Tammy or whichever legal assistant is in the office." We don't want barriers. I don't talk to people from behind a desk, and I don't want to talk to them behind a title. And I will learn everything about them, not just the stuff about the criminal case. Everybody does that. Everybody should do that. Our form fills that out. But I want to know personal things about them. My favorite question: when is the last time that you had fun? And it is sad to hear the people say, I don't remember. But some of them do, and you find out from them what they like. A little in-depth family information. People love to talk about their family, and as they do, you begin to get a sense of who they are. Another favorite question: do you have any pets? Oh, you got a dog. What kind of dog do you have? Why is it an important question? A 240-pound behemoth that looks like he's an enforcer for the Hells Angels, who has 2 Shih Tzus and a Dachshund, is a different person than that same 240-pound person who has 6 pit bulls. You can determine so much from little things like that. What would you do? Where would you go if you could take a vacation? Any place in the world. You find out how broad their horizons are and maybe a little bit of who they are. I'm concerned about people's health. When's the last time they had a physical? How much sleep do they get? What are their favorite foods? Do they exercise? Virtually every defendant in a criminal case has 3 problems: stress, lack of good goals, and low self-esteem. Good, hard physical exercise is the best prescription for some of these, and we talk about that. We talk about church affiliation. I always tell my clients something about me and my lawyer partner, Brett Harrison, who does criminal cases with me, our firm. If there is a spouse, or if they're parents or children, I like to have them, adult children, come in to the next interview so that they see that I've got 2 arms, 2 legs, and a head, and I'm interested in whoever it is that they're with. When these folks leave my office, or when I leave them in the jail, I want them to believe that I am going to do everything I can to help them and that I truly care about them. And I tell folks in the hired business, don't hire me unless you believe this. We can't become a team unless we have trust. I will tell you that I believe strongly that criminal defense lawyers have the opportunity to make a greater impact upon their clients than all the judges, mental health professionals, social workers, probation officers, prison guards, and probation and parole officers working together. We can get our people involved in counseling and drug and alcohol cases and in anger management cases. I have no doubt that we have prevented a number of suicides by having people go from our office to the office of a licensed professional counselor immediately when they said the word suicide. We can place them with other lawyers for legal problems that also are there, which they didn't even realize. And sometimes we make appointments with them for a physician before they leave the office. What are the enemies of the court-appointed lawyer? Alex, I'm envious. You're in better shape than those of us in East Texas, I will tell you. Time is the first enemy. 24 hours a day, 7 days a week, that's 168 hours. You have to allocate some of it for family. You have to allocate some of it for sleep. You do have to eat. And there's just not enough hours in the day to get it done, whether you're hired or appointed. And the appointed people are so much worse off on this than we are who do only hired. You know, I realize that even though I take court-appointed cases, I don't play in the same arena that the folks do who do this for a living. The folks who do this for a living are, in my mind, like the troops who are in Afghanistan or Iraq. They're up to here with work. Their family appreciates what they are doing. Some of their friends do. But there are a whole lot of folks in society who have no concept of what they are doing and have no appreciation for the work which they have to do. Our caseloads for many of our court-appointed people are impossible. I do a lot of research. I do a lot of writing. I would hate to think that I had to do 70 briefs a year, and these aren't cookie cutters, and they're getting reversals, but I don't know how they have the time to do it. There's an area of time which I am concerned some court-appointed lawyers do not put enough emphasis on, maybe because they just don't have it. But the time to sit and reflect and think and try to figure out what they can do in a case. Because cases are sometimes won, because the state simply did not appreciate the theory of the defense and had not anticipated it. And the trial court didn't either. I write about 10 columns a year for the Voice of Defense, the magazine of the Texas Criminal Defense Lawyers Association. And I see great lawyering in cases all over the country where someone came up with something that nobody had thought of, but they did. And if you think back, all these cases that we have on confessions and search and seizure and lineups, with maybe Mr. Gideon's case is a semi-exception, got there because a lawyer had an idea and he pursued it, and everybody said, "You're wrong. It can't be done that way. That's not the law." But they were right. They had come up with a theory, and it worked. The opportunity to do good legal research. We have too many defenders who have to spend time with O'Connor's manual as their be-all and end-all. And I was talking to a lawyer in a different county. The commissioners had cut off the defender's right to, or access to Westlaw, and how you can try a case without having access to Westlaw or whatever the other one is. I don't know. I've been a Westlaw person all my life. But there's just not enough time. Then there's the enemy of money, the threat of money. What's the mantra of the average public defender or person who's working as a court-appointed lawyer? We have done so much with so little for so long that someday we will be expected to do everything with nothing. This is an area where we in private practice have a fantastic advantage. I looked at our books for 2009 and 2010, found that we had spent $97,000 plus in 2009 and $153,000 in 2010 for mental health professionals. And we needed them in every case that we had them, and they were worth every penny. And court-appointed folks who are doing it probably can't come close to being able to have that kind of resource. There's the money for staff. I know too many court-appointed counsel who simply don't have anybody in the office except themselves. And if you call on the phone, it's full. You can't even leave a message. And I don't know how they're able to do what they do. But there is an answer for this. It's called judges. We all know that judges are the gatekeepers on issues of the admissibility of scientific evidence. More importantly, they are the gatekeepers on whether the lawyers who are representing indigent defendants have the opportunity to play on a level playing field, or whether they are down in the valley with the state up on the mountain. Smith County is an unusual county in so many ways. Trust me, it is. The district attorney in Smith County does not have a limit on what he can spend for anything. There has never been a concern about the district attorney's budget. Tim Proctor is a forensic psychologist out of Dallas, Texas, who often makes more money as a as an expert for the state than the district attorney makes. Now, the blessing of this is that the judges understand this. And so the judges, in order to see that we have a level playing field, are attuned to the need of defense lawyers to get experts also. And let me give you an example. In 2004, there was a woman in East Texas, actually 2003, there was a woman in East Texas who was told by Almighty God that she should kill her children. And there were only three issues. Should she do it with a knife? Should she do it by drowning them? Or should she do it by stoning them? And after listening to God, she determined she would stone them. And yes, she was delusional, grandiose. And she killed her children, two of them, injured a third. It was in the Sunday paper. I came in on Monday morning, saw Judge Cynthia Stevens-Kent, and said, "I'm surprised I didn't get a call." She was out of town. She said, "Would you take the case?" I said, "Of course." She was on the bench for years, and she never asked me to take a case that I didn't. I said, "I'll take it if I can have the money to defend the case." I go over and see my new client, and I tell her I'm Buck, and she said, "I knew you were coming." "How did you know I was coming?" "Because when I was in the pasture waiting for the police to get there was a 6-point buck, and I knew my lawyer would be named Buck. I called George Parnham, who had represented Andrea Yates, and said, if you had Yates to do over, what would you have? What would you have available? He said, I'd want her on videotape that day. I called a licensed professional counselor. He went over, did a video in the jail, and said, she's got problems. You're going to get an insanity defense. I called Phil Resnick, who is one of the authorities on infanticide in America. He's at Case Reserve up in Cleveland, Ohio. And I said, will you come down? He said, yes, but you got to give me $10,000. Now, remember, I'm working at about $90 an hour. I go back and see Judge Kent, and I lay it out and say, I've got to have a check for $10,000. And she didn't immediately say, sure, Buck, do it. But after we visited, she said, do it. So Resnick and his team come down. He brings 3 board-certified psychiatrists who are doing their residency in forensic. And they come down and interview her, and they do a videotape. And then when all the experts wind up getting in eventually, 2 for the state, 1 for the court, they come down and interview her. And she is as sane as she can be because the medication has worked. And she's competent. And they all said, gosh, if we hadn't seen that tape, we would have found her to be legally competent and legally sane. She obviously was delusional, grandiose. 3 former presidents of the American Academy of Psychiatry and the Law. 1 wonderful psychiatrist who was not a member. We tried the case. Jury comes back and finds by a preponderance of the evidence that she is not guilty by reason of insanity. If Judge Kent had not let me have that money, I would not have been able to prepare and present a defense in the case. It is the judges of the state of Texas who determine whether or not court-appointed counsel can get a fair trial, whether or not there is a level playing field. Interesting enough, in that restitution case that I mentioned earlier, a federal judge turned me down and said, you can't have any money to do your work in this case. And I got the family to come in and do the money and get the experts that I needed, 2 wonderful experts. And we have the hearing in the judge's court, and the district judge goes from, it's just a matter of who pays the money and how much, to she doesn't get a penny. She's not entitled to it. And then told me he would reimburse my client for the expenses. So lawyers, to do what they need to do, have to understand Akey versus Oklahoma and make their applications. Problem, the unhappy client. Defendants who go to the penitentiary really don't want to be there, and whom can they blame? They can blame their lawyer. And so consequently, one of the things that I do is the ex parte hearing, and I do more of them than all the other lawyers in Tyler put together. We have a hearing in front of the judge every time it's a capital case, and we're challenging jurors. And every single time before we do the challenge, we have an ex parte hearing, and my client agrees to what I am doing and to my strategy, and that pretty well settles it on whether or not we are doing what we are supposed to do. I've never understood how some defenders can go back day after day and get kicked and come back. There has to be a little bit of a self-esteem issue, but these lawyers who do it day-by-day basis seem to have gotten over it. We all understand that winning is doing the best you can, winning in the criminal justice system. Winning is doing the best you can to get the best result that you can. And there's no doubt that our defenders are doing that. What have I learned? If you're doing this work, you've got to be a member of Texas Criminal Defense Lawyers and NACDL. We've got to be like comedians. We've got to learn from our companions. Highest compliment is to steal a routine in comedy. Highest routine in the law is to learn from somebody else. Practice the finger exercise. Finger down, over, back, up. Means you can use a touch-tone telephone and call somebody else who's been there and say, how do I do it? I cannot tell you how much I appreciate your staying still for the 29 minutes and 38 seconds that I've talked so far. I'll leave you with one thought. I can't tell you what a difference it's going to make that a criminal defense lawyer is president of State Bar of Texas, but I will tell you this. I have believed in and been passionate about right to counsel in court-appointed cases, and I shall continue to do so. Thank you very much.